Hey everybody, asset protection attorney Brian T. Bradley here, and I'm sure you guys have watched some of the videos on asset protection and heard me on different podcasts and networks talking about asset protection and different layers of protection. Our firm focuses with higher net worth clients and high risk professionals. Kind of what do you do when you outgrow that LLC and turn that 1 million net worth mark? And a big question and new concept that I want to talk about today is, how is a bridge trust or a foreign asset protection trust both an foreign asset protection trust offshore and maintain a classification domestically? How can you do this? And so it's a big question and a new concept for people, learning about asset protection trust and domestic and foreign asset protection trust, and our hybrid, bridge trust, and this is the concept of migration provisions. And so what this, what is this? How can this, be an asset protection trust that's foreign and domestic? How do we do this? And so what you need to remember first is that the bridge trust is just an irrevocable tax neutral grantor trust. That's what it's going to be, a grantor trust, whether it's domestic or foreign. It's going to be a domestic grantor trust or a foreign grantor trust, just depending on if we maintain compliance with domestically or not. So the way a foreign asset protection trust can meet the criteria to be classified as a domestic asset protection trust, yet still keep the power and strength of the Cook Islands Asset Protection Trust, is through what asset protection attorneys call, again, migration provisions. We're maintaining compliance with IRS Section 7701, and this is known as the court test and the control test. So in the case of the court test, offshore trusts can be drafted so that the US and the foreign jurisdiction supervise the trust. They both can do this. In the event of a legal crisis, like a lawsuit, the trustees have then the option to allow the trust to migrate to a foreign jurisdiction, cross the bridge. Only at that time of migration does the trust actually become a foreign trust, for asset protection purposes. Until then, it's just a domestic asset protection trust. And this is done by dropping the compliance with IRS 7701, and the trust is now purely a foreign asset protection trust. And so the same type of migration provision applies for the control test as well. During times of normal operation, a U.S. trustee, can act with respect to the trust, and the assets in there without the consent or any consent of a foreign trustee. They're not in effect yet. In the event of a crisis, like a lawsuit that threatens the trust and the assets in the trust, there's a resolution by the trustees that can affect the migration of the trust to the control and give control to the foreign trustees. So we're dropping you as the trustee now. You're no longer going to be named as the trustee, and then the offshore Cook Island trustee takes over. The bridge trust is unique in it's a foreign asset protection trust, but the IRS, again, classifies it as a domestic asset protection trust, so long as that IRS compliance is maintained with. It's not offshore until it's needed to be, but you still have the offshore component because it was created to be both foreign and domestic. And you want that. So it's more flexible. You want the domestic classification for the flexibility. You get the benefit of both the domestic and foreign trust together, all in one. Being classified domestically keeps down the unnecessary IRS asset disclosures and filings that you'd have to make to be purely foreign. And it's going to be cheaper on your annual maintenance costs. A lot of purely foreign asset protection trusts are going to be upwards of $5,000 to $10,000 a year annually to maintain. Bridge trust that's classified domestically is going to be about $2,100 annually. That's a big difference, yet you still have the strength of the Cook Islands if and when you ever need to trigger the bridge. If you ever are attacked and you and your attorney decide that it's in your best interest to actually trigger the bridge and cross it to the offshore jurisdiction, you already have that foreign option available in your back pocket. You would drop the domestic components again, and then you would not be in compliance with the domestic requirements of the IRS. And now you're purely a foreign grantor trust. Until that threat goes away, that's where you want to be. At that point, you'd have to make it the additional IRS foreign asset protection trust disclosures, and the maintenance costs would go up. They'd increase while you're purely foreign. Then when the threat goes away, the lawsuit is settled and it's gone away. we bring the asset back domestically with no tax implications or penalties. And so this is the benefit of having that hybrid system. And so if you have any questions, feel free to email me, Brian, Brian at btblegal.com, or you can always jump on my website at www.btblegal.com. I have lots of educational information and videos and lots of podcast features. And I've been on, other networks talking about asset protection and higher levels of asset protection. But this migration provision and IRS compliance is what we're working with when we're combining domestic and foreign asset protection trust. So I hope this was helpful and shine the light on some confusing area of how these trusts work. Have a great day and hope you keep investing.